Hello, my name is Catherine Terser with Common Cause Ohio. I want to welcome you all today. You'll see that there's an area for chat. In the chat, I'm going to encourage you to throw your name and where you're from into the chat. And then there's like a Q&A area. And so that's a questions answer area. So if you have questions, Maria Bruno, who's going to be moderating this, will be looking for your questions. So she has some of her own questions, but she's going to be looking for questions. Now, I notice we have a few people who have added their name and where they're from. I want you all to keep it up. I think it's helpful to know where you all are from. We went from Akron all the way to Cincinnati. And the thing that's exciting is that we are all here today because we care about our courts. One of the things that makes this time period incredibly difficult is the cognitive dissonance between what we hope for the courts and what we actually have. And so what I'm hoping today is that we have a good conversation about, well, what is the lay of the land? What's going on with the U.S. Supreme Court? And what can we do to make that vision of a justice system that doesn't have a hand on the scale? How can we actually make that a reality? And with that, Kelly, if you'll move us along, I did want to highlight, any event like this comes together because of a bunch of different people. So we are co-sponsored by the Ohio Fair Courts Alliance. We have the ACLU Ohio here. We also have the League of Women Voters of Ohio and the Ohio Environmental Council. One of the things that I want to highlight too is the Ohio families coming together, the OFU PAC. There's something really beautiful about coming together, seeking justice with a real focus on the family as well. And, I can hardly shout out Common Cause because I am Common Cause. But this is the kind of thing that I always feel like it's so important for us to not just read about what's happening in Washington, not just to feel the consequences of what's happening in Washington, but to actually have conversations about what we can do and how we can make things better, because we deserve better. And with that, basically, what we're going to do is, you'll notice a welcome. We're also going to hear from both of the panelists, and Maria Bruno is going to walk us through a discussion of all the different issues. The Q&A section really is the section that is all about you. This is the area where we're going to encourage you to put questions in that Q&A area, and then Maria will be asking the questions. And so with that, I'm going to hand this over to Maria Bruno. So the thing that's wonderful about Maria is that she has been actively engaged for many years with the Ohio Fair Courts Alliance, beginning with the time period where she was with the Coalition on Homelessness and Housing. When she was there, she did a lot of work on voters' rights. She also, for many years, you'll know her because of working with Equality Ohio, and she has a brand new organization, Ohioans Against Extremism. Now, Maria is a very accomplished person. She is somebody who went to Ohio State Law School, and I am sure she's going to guide us through a really good discussion. And with that, Maria, I'm handing it off to you.
Thank you so much. What a wonderful introduction. Hi, everyone. My name is Maria Bruno, and I will be your moderator this evening. I am lucky to be joined by Lisa Graves with the True North Research, as well as Gabe Roth with Fix the Courts. I'm going to let them speak for a few moments about their kind of bread and butter issues, and then we are going to go ahead and have that discussion that we mentioned. So Lisa is the founder of and executive director of True North Research, a national investigative watchdog group that works with journalists and other researchers to shine a bright light on dark money. Her investigations have been featured in Ava DuVernay's Oscar-nominated documentary, The 13th, and in a PBS documentary narrated by Bill Moyers entitled The United States of Alec, among others. Thank you so much for joining us, Lisa, and I will pass it off to you.
Oh, thank you. Thank you so much, Maria. So am I supposed to just say hello and then go to Gabe and then come back? Or just jump right into 10 minutes of sharing?
You can jump right in.
Okay. All right. Well, thank you so much. And thank you everyone for coming this evening. It's really wonderful to see such a terrific turnout from folks who are really concerned about our courts. My name is Lisa Graves, and I first started looking at the courts and judicial issues more than 30 years ago. And for a period, I was the lead staff attorney on judicial nominations for the U.S. Department of Justice, working with my boss, who led the Office of Legal Policy, and working with the White House in the Clinton administration to try to help get fair judges appointed to the courts. In that period, we were faced with some real difficulties from the United States Senate, which at the time was controlled by the Republicans, and they were making it very difficult to move forward a number of judges. Nearly 70 judges were blocked back then. Another one of my jobs at that time for the Justice Department was to advise the Attorney General on basically judicial relations issues in terms of the relationship with the U.S. Supreme Court, the Judicial Conference, as well as the state Supreme Courts and state Chief Justices. And then I went to work for the Administrative Office of the U.S. Courts. I was the Deputy Chief of the Article III Judges Division, which had oversight over the Financial Disclosure Office, which was a pretty obscure, very little known office, but recently has become a much more well-known office because of the issues involving financial disclosure. And then I became the Chief Nominations Counsel for the Senate Judiciary Committee for Senator Patrick Leahy, where I worked to try to protect the courts from people being put on the courts, on the federal courts, who were unfair or chosen in order to rule a particular way. So that's a bit of my background I just wanted to share before we jump in. And I realized that my slides are out of order, unfortunately. And so I'm going to ask when we move forward to direct to a particular slide so that we can get them in the right order. But let me just, it was my fault, just to be clear. The team over there at Common Cause and Fair Courts Ohio and ACLU had nothing to do with my slides. So just wanted to flag that. But let me just begin now sort of where we are. We are in a situation in which there's been just a tremendous amount of disclosure, not by the justices of the U.S. Supreme Court, but by the press. There's been just an enormous amount of really deep diving investigative work by investigative journalists at a number of publications, at ProPublica, at Politico, at the New York Times, the Washington Post, Rolling Stone, Slate, numerous other outlets that have really helped to shine a bright light on what's happening to the U.S. Supreme Court. I definitely want to flag, at least from my perspective, that we helped start some of that investigation. I actually worked a lot on responding to the Kavanaugh nomination a few years back in 2018. And at that time began a deep examination of a person whose name was not well known, was known in some quarters, but who it seemed had been amassing millions of dollars, in fact, hundreds of millions of dollars, to influence the U.S. Supreme Court, who was on the court, who was on the lower federal courts, and who was even on the state Supreme Courts. And his name, you all know, I'm sure, is Leonard Leo. And so there was a tremendous breakthrough in the Washington Post in an investigative report by Bob O'Hara and Sean Boberg in May 2019 that really uncloaked this dark money that had begun swirling around the U.S. Supreme Court in terms of pushing people onto the Supreme Court who were very controversial, like Neil Gorsuch and Brett Kavanaugh, and then ultimately Amy Coney Barrett. Also, the forces that tried to stop and in fact succeeded in stopping Merrick Garland from being appointed to the Supreme Court, even though President Obama had been duly elected twice and won both the popular vote and the Electoral College and had every right to nominate someone to the U.S. Supreme Court. So just to fast forward to the subsequent nomination that was in the news, Ketanji Brown Jackson, during that nomination, we were looking closely at the activities of Leonard Leo-tied groups, in particular, this thing that was called the Judicial Crisis Network. It's now rebranded as JCN. JCN had announced that it was going to spend over $1 million, I think it was $1.4 million, on ads basically against Ketanji Brown Jackson. Again, that was dark money. It was money that is not required to be disclosed in terms of who the sources are, money that was not known to the public who the sources were. And when we looked into that ad campaign, what we found was that it was really not about Ketanji Brown Jackson. It had a mention of her, and the mention was that she supposedly didn't like Clarence Thomas. And then the whole ad was really about how great Clarence Thomas was. And then at the end, it linked basically to a biopic about Clarence Thomas. So we looked at the Clarence Thomas biopic, and it turned out that it was funded by billionaires, including Harlan Crow. So we knew about Harlan Crow from some tremendous work that had been done by Common Cause and others back a decade earlier. And when we saw Harlan Crow and these other billionaires bankrolling this film about Clarence Thomas, in the film, Clarence Thomas, says that he preferred his RV to camping on the beach or anything of that nature, and that he was really just a man of the people. And yet it later turned out that that RV had been purchased for him by another super rich guy, and that he didn't pay back all that loan. That was part of the investigation by the Senate. And as I mentioned, the film was funded in part by Harlan Crow. So we went looking for photos of Clarence Thomas with all the billionaires that were bankrolling his biopic about how modest he was. And we found a photo that you now have seen widely shared. It's the photo of Harlan Crow and Clarence Thomas and Leonard Leo at a camp actually at the estate of Harlan Crow, his upstate New York estate. And that photo really became one of the centerpieces of the major, incredible investigative work by ProPublica that was published last April, where they, knocked on doors, talked to the yacht crew, talked to the jet crew, I presume, talked to the people at that resort, found more examples of Clarence Thomas flying on Harlan Crow's private jet, found how the yacht had been moved to New Zealand for a special trip that Clarence Thomas and his wife Jenny were on. Also found that they were on a Greek islands tour, on and on and on. And almost none of these trips were revealed or disclosed. In fact, none of those yacht trips were disclosed in Clarence Thomas's financial disclosures, nor were the private jet flights that Harlan Crow was letting Clarence Thomas and Jenny Thomas use his jet to go to various locations in the U.S. When ProPublica started to examine these trips that were Harlan Crow funded, they found other trips. They found trips where Leonard Leo was basically helping to coordinate the travel of Samuel Alito to a fabulous salmon hunting or salmon fishing trip up in Alaska. And it turned out that Sam Alito had also flown on a private jet by another billionaire who had interests that would come before the court in some form or another in terms of the regulatory industries. And then Alito basically tried to claim that, there just happened to be a private jet going to the same location as him. And so he just caught a ride. It just happened to be the same jet as Paul Singer, the billionaire who was flying up to that very same trip with Alito. The fantastic reporters at ProPublica also uncovered information about how Clarence Thomas had gone to events at this all-men's club, exclusive all-men's club north of San Francisco, where Harlan Crow, along with David Koch and Charles Koch, the Koch billionaires, had attended sometimes. And also that at least one of those events, Clarence Thomas had talked about how he was really working to overturn Chevron, this case that was most recently overturned this term. But that's not all. The Washington Post uncovered that Jenny Thomas had been secretly paid by a nonprofit tied to Leonard Leo, and that Leonard Leo had made that secret arrangement for her to be paid. This was back in 2011, 2012, a six-figure sum. When Politico looked into that, they found that there was no, when they asked Leonard Leo and the group involved whether this practice had continued, whether they were still paying Jenny Thomas under the table, basically through a secret arrangement, they declined to respond to those queries. So, I tell you those stories just to reiterate some of the the volume of amazing things we've heard uncovered over the past year by truly excellent and just relentless investigative reporting. One of the most significant parts of that reporting, I think, was a story that came very late last year, which was about how Clarence Thomas back in 2000, when Bill Clinton was president, when Gore looked like he might win the White House, and in fact did win the popular vote and should have won the Electoral College vote. But back then, Clarence Thomas was telling people that he wasn't making enough money to stay on the court. He wasn't living in the lifestyle to which he was accustomed to, and he might resign. And so that really was a key story in telling, like, why was he on this gravy train? Why has he been taking all these trips? Why has he been accepting all these gifts and not disclosing them? It's really in part because of this desire, at least that was documented by ProPublica, to live the lifestyle of the rich and famous. And so in essence, this gift trail has been designed to keep a sure vote on the Supreme Court. So if you could go forward to slide number 7, that would be great. I'll tell you when to stop. Stop, not there, keep going. All right. So slide number 7 is about the Senate. Oh, we might not be able to do the slide. Sorry about that. Slide number 7 is about the Senate. It's about the investigative work, the oversight and reform that the Senate has pursued to try to get to the bottom of this, including the Senate Judiciary Committee, as well as the Finance Committee, the issuance of subpoenas and more. There's really just been building momentum. If you go back one slide to slide number 6, the House has joined that effort. There's been a tremendous effort from the beginning with Senator Whitehouse in the U.S. Judiciary Committee and Hank Johnson on the House Judiciary Committee. But that effort has now been expanded along with this special task force being led by Jamie Raskin. Tremendous efforts on the House side, including a straight up gift ban to try to stop this type of gift giving to Supreme Court justices. If you go back one more slide to slide 5. Or that's what, actually, that's good. Stop there. That slide, in response to these disclosures, at first the Supreme Court refused to take action. Roberts basically said, there's nothing to see here. We all follow these ethics codes. Don't worry about it. Despite the fact that the investigative reporters had documented how, in fact, that whatever ethics code they were following was meaningless, basically. Then right before the Senate was about to issue subpoenas to Harlan Crow and to Leonard Leo, John Roberts orchestrated the announcement of the release of an ethics code that the Supreme Court has said that it follows, that had zero enforcement mechanism, and in fact provided lower standards than other federal court judges are required to follow under the Code of Conduct for U.S. judges. If you go back one more slide backward. And what has happened in the meantime is that there's just been this tremendous public response to this corruption that has engulfed the court. No matter what John Roberts has said, and all these evasions and defenses of Alito and Thomas and Justice Scalia before them, the people get it. The American people understand that this court is out of control, that it is not following ethics rules, that it is, in fact, guided more by its agenda than by fairness. And I think that's exactly what is happening. That's what's happening in our country. And that's why we have to come together to support court reform. And before I pass the baton back to you, Maria, and then over to Gabe, I just want to say that, this issue is not just a generic issue about, ethics, although ethics and morals are certainly deeply important, especially for our courts, including the highest court in the country. But it also is having an impact on the decisions that the court is issuing. This court is advancing an extreme agenda that is fully aligned with the right-wing funders who helped get these judges on the court, who helped secure their confirmation. It's fully aligned with the agenda of Leonard Leo, who handpicked most of the judges in that faction, of that 6-3 faction on the court, and who helped also work on the confirmation of Clarence Thomas back, more than 30 years ago. So it's not just that these judges are behaving in this unethical way, and that's bad. It's that they're behaving in an ethical way, and in the process, they're remaining on a court without any consequence in order to advance this extreme agenda. And that agenda, the agenda of Leonard Leo, has been to overturn Roe versus Wade. It has been to limit the ability of our federal government to regulate corporations, including industries and corporations that some of the benefactors of Leonard Leo and his court packing agenda have sought. And it has also fueled what I call the amicus racket, what Senator Whitehouse has called this flotilla of amicus briefs, basically by these right-wing groups, also funded by many of these same right-wing funders or tied to Leonard Leo, who then come into court to try to make the case, in essence, to signal to the court that these are the changes they want in the law. And this Supreme Court, this right-wing Supreme Court faction that is helmed by John Roberts, includes Clarence Thomas and includes Sam Alito and Neil Gorsuch and Brett Kavanaugh and Amy Coney Barrett, it has been determined to rewrite our laws and rewrite our rights, including issuing what I consider to be the most reckless, the most dangerous decision, honestly, that the Supreme Court has ever issued, to give retroactive immunity for criminal activity to Donald Trump, and to basically create a situation in which there's potential future immunity from future crimes by a future president. And these are matters that are not, anywhere in this Constitution. This Constitution does not give a president immunity. It contemplates expressly the opposite, that a president has a duty to faithfully execute the laws. It says that twice in our Constitution. It also provides, obviously, for a president to be impeached for high crimes and misdemeanors. And so this is a truly lawless decision. It makes me very concerned about what this court might do in the face of election challenges in this 2024 election. But we'll leave that conversation for another day. I just want to say the ethics matter, and it also matters that what we now have is a court that is constituted illegitimately and includes people who have no business ruling on some of the cases they're ruling on, including that immunity case with Clarence Thomas and his wife being actively involved in trying to overturn the election, as well as with Sam Alito flying the flag over his home that was the flag associated with the violent insurrection on January 6th, and then turning around and ruling on cases involving January 6th. That's not the least of it. There's more to talk about, but that's my opening. And so sorry that my slide deck was out of order. All my fault, not the team's. And back to you, Maria.
Thank you so much, Lisa. That was very informative. I know there was a lot there. If you have questions for Lisa, please throw it in the chat. We will, as Catherine mentioned, have a period for discussion. So please do ask those questions. We're going to introduce our next guest, who's going to keep the conversation going. We have Gabe Roth, who is, again, the executive director of Fix the Courts, which advocates for non-ideological fixes that would make the federal courts, and primarily the U.S. Supreme Court, more open and more accountable to the American people. Gabe founded the organization in 2014. Previously, he managed the Coalition for Court Transparency, a national alliance of media and legal organizations that advocates for the broadcast of Supreme Court proceedings, which we can very much appreciate, Gabe, because as folks sitting in Ohio, we really appreciate when we have that access to that court. So thank you, and I will hand it over to you.
Thanks, Maria, and thanks so much to Common Cause and the other groups for having me tonight. The crickets are out in full force in Virginia, so hopefully you can hear me okay. And if not, I guess one of the moderators will tell me. But if you could go to the next slide, please. My background's a little. Oh no, that slide died. Half of it is gone. I'm sorry. Anyway, yeah. So Lisa talked about SCOTUS, so I thought I was going first. So I guess I don't need the slide. But could you go to the next slide, please? Then. So yeah. So my background is not in on Capitol Hill or in the federal government. I haven't worked in any of the three branches, like Lisa has, let alone all three. Or unlike Lisa, I haven't worked in all three branches, and I haven't worked in addition any of the branches. My background's in broadcast journalism. I went to journalism school for grad school and worked in TV news for a while, and then moved over to advocacy. And a lot of the cases, a lot of the clients that I had cases in federal court, but they were based in Maine or Texas or California, and I was doing PR for them, and they had all assumed that they could should their case reach the Supreme Court. Just watch it on C-SPAN 4, which, as you guys know, is not a thing. So I started, next slide, please, the Coalition for Court Transparency. Oh man, we missed a slide too. It's out of, okay, maybe it's the next one. Can I share my screen? Is that cool? I mean, it doesn't really matter that much. It was just going to show little cameras next to Sam Alito's face.
I mean, that does sound pretty important, to be clear.
So let's see. I don't. How do I share my? Oh, share. Here we go. This guy. Okay. So yeah. So I got my beginning by journalism, I said, and so, you know, this idea of not having cameras in the court was one that was really near and dear to my heart, being a former broadcast journalist, and not being able to see the justices in action, having to schlep to the court, stand in line, and I still have to do this actually if I want to see them, though now there's live audio. Stand in line at 5 a.m. With the hope of getting a seat. There are 350 to 400 seats in the courtroom, but only about 50 members of the public actually get in to hear one of the justices' 60 oral arguments a year, and usually they're 2 a day, so it's really only 30 days during the year in which there is an oral argument, and it's almost impossible to get a seat unless you know someone. And even if you do, like me, you still got to stand in line for 5+ hours, and even longer if it's a major case. But you know, it's not that hard to get cameras into a Supreme Court. Every Supreme Court in the United States has one. It's when the justices testify before Congress, as they do from time to time. They're tiny little cameras that are placed around the room, and they're non-obtrusive. And there's a way to bring transparency to the court. Live audio is great, but you get a lot more information seeing what goes on in the court versus hearing it. That's how we get our news nowadays. Our news is optimized on Twitter and Instagram and TikTok, and if Facebook's still a thing, probably Facebook, with video. So you're more likely to see what's going on in the high court of the land and understand what's going on if there is a visual to go along with that, which we don't have, which is unfortunate. So that's where my background is. The thing is, though, is about 10 years ago when I started this Coalition for Court Transparency, I realized that it wasn't just the broadcast issue that made the Supreme Court so, as Lisa was talking about, non-transparent and unaccountable. It was the fact that they could serve for life, the fact that they, at the time, didn't have a code of ethics, and now that they do have a code of ethics, it's unenforceable. The fact that they're allowed to trade stocks with all sorts of impunity if they have conflicts of interest. Their financial disclosures are bare bones, and oftentimes justices, as Lisa alluded to, leave things out of their financial disclosures that's incredibly important. And we don't know when they're appearing in public, or if they are appearing in public. And Justice Gorsuch is on a book tour right now. He's only speaking to conservative audiences. He's only, you know, Megyn Kelly, Ben Shapiro, 3 Fox News appearances. The CBS News reporter he spoke to used to work at Fox. The PBS News reporter he's speaking to is a Republican and is the great-granddaughter of a Republican president. He's only speaking to conservative audiences, and he's the justice for 330 million of us. He should be trying to speak to more than just the home team. So those are the 6 fixes that as you can see on the side. And we do some similar work to Lisa. We do research on different ethical lapses that the justices may commit over time, gifts that the justices don't report, travel that the justices don't report, errors that they make in their disclosures. We do this via lobbying campaigns and coalition building. We work a lot with Capitol Hill to get our message out. And, you know, one of the things that I think is important to bring up is, you know, Lisa's talking about all these different cases, instances, not cases, but we'll get to the cases, instances where the justices are clearly interacting with individuals who have business before the court. Maybe they're not the litigant, right? It's not Harlan Crow versus US or Leonard Leo versus US, but they clearly have interest before the court. And even if we don't know about it, it is the duty of the justice to say to him or herself before they agree to sit on a case, should I be hearing this case? Are they on my recusal list? Every justice has a recusal list that there's a paper version, there's a version that's fed into software. Is this case, is it reasonable for a person, and I'll just pull up the federal law, any justice whose impartiality might reasonably be questioned, shall disqualify himself. So these issues that Lisa's talking about with Harlan Crow and with Paul Singer, could somebody possibly believe, or the upside down flag, or the January 6th involvement of Ginny Thomas, could a reasonable person possibly believe that Thomas and Alito in these cases are conflicted out because of their or their spouse's entanglements? And the answer is, of course, yes, right? We have the situation where the justices are not following the law. It is a law. It is a federal law, 28 U.S.C. 455A, that says a justice shall recuse if their impartiality is reasonably questioned, and that's not happening, and that's a problem. And what can we do to fix that? We can talk about what it means enforceable ethics during the discussion, but overall, it's clearly a problem. Oh, that's it? Oh, I thought I had more slides. Okay, I'm going to stop sharing. Good, because I was reaching my time anyway. But yeah, I think that it's that there is room for a little hope, for a few ways to change things at the court. I think the justices are actually a lot more responsive, and Congress is frankly responsive as well. And not to say that tomorrow something's gonna happen, a law is gonna pass, and we're gonna have a ethical court, but I do think that over time we are moving in the right direction to where the court will be more accountable to the will of the American people, and hopefully that makes it more responsive to what we want and not so reactionary.
Thank you so much. Now I'm going to invite Lisa back to the discussion. So the three of us are just gonna have a chat. I'll open with a few questions, and then I will pop some of the questions that were floated in the chat to you all as well. But I did want to start with one piece of just like context for the non-lawyers out there, which is, Lisa, you had talked a little bit about the flotillas of briefs. And I think for non-lawyers who are less familiar with litigation, they might be going, I have no idea what that means. So when you're talking about that, we talk about when they have business before the courts. And I think probably logically we think, okay, well, that's when they're a party, right? Like they are directly named in a lawsuit. That's when they have business before the courts. So can you just expand upon, before we jump into our other questions, and either of you, I'll start with Lisa since you're the one that sort of brought it up, but and my cat is breaking into the screen. But if you could just explain what you mean when you're talking about these briefs to the Supreme Court, what the role of those briefs are, and how they shape how the Supreme Court is making their decisions.
Yes, thank you so much for the opportunity to clarify that, Maria. In general, in any lawsuit, you have the parties to the suit, the defendant and the plaintiff, or the United States and the criminal defendant, or the accused. And what has been happening for more than a century, really going back to some famous briefs called the Brandeis briefs, where Louis Brandeis, before he was put on the U.S. Supreme Court, was trying to make the case for the impact of some of the labor abuses that were happening in our country at the turn of the century, in the era of the robber baron, in the Industrial Revolution, and was trying to put forward briefs that really provided additional information for the court to understand the impact of these policies on people's lives. And so that's the genesis of these briefs. But what's happened really over the last couple of decades in particular is that we now have so many briefs coming to the court. Some of them are by groups that barely even exist on paper, let alone, with a website. Many of them have no requirement. In fact, almost all of them have no requirement under the law to disclose who their funders are. They're required to disclose who funded that brief. But then if someone provides general support to that group and didn't expressly fund that brief, they're not required to be disclosed. And so we have this massive number of briefs coming in. It's almost like an industry, a cottage industry, basically. And there are briefs on both sides, but what's been happening on these right side briefs is that we know through other disclosures, through leaks, and other investigations, that a number of these groups that are on the right that are submitting these amicus briefs known as friend of court briefs, meaning they're not a party, but they're saying, I'm a friend of the court and here's my view. A number of those briefs are funded by the same entities, same funders, who also funded the efforts to get some of these judges confirmed to the U.S. Supreme Court. So help push them through despite their controversial backgrounds or in my view, their unfitness for those appointments to the bench. And so Senator Whitehouse has done a number of speeches on this. He also wrote a book about the captured courts. I would definitely urge folks to take a look at those. And he has a bill that he's introduced called the Amicus Act, which is designed to require, much more detailed disclosure of who's really involved in the groups that are bringing these briefs to the court. And there was a really important story in Politico earlier this year, or might have been the end of last year, talking about how the Supreme Court was citing some of the claims in some of these briefs that have been debunked, things that are just false, for example, about the history of abortion in America. And so these briefs have come in and they're actually being incorporated into Supreme Court decisions in ways that are deeply erroneous and false in order to create a false or cherry-picked history in order to destroy our rights. And so it really is a problem.
And I'll just add to that. Today, actually, the U.S. courts announced that they're looking to implement a new amicus policy, and they're accepting comments on it. And the policy came out of Sheldon Whitehouse's work and some others' work. But it would basically require more disclosure. So if you've given more than $100 towards the writing of the brief, or if you are an entity or individual who has given donations that total more than 25% of the brief writer's revenue for the year, then you have to disclose. And there are a few other additional disclosures, but if you just go to uscourts.gov and click on the news site, it'll be the first thing right there. So if anyone wants to write a note saying that they support this, or it doesn't go far enough, maybe, I don't know. I think it's given who led it, this former judge that did some pretty nasty things during the Bush administration. Jay Bybee is the head of that committee. He apparently got a conscience and now is heading this appellate rules group and putting out some pretty decent rules. So, I think we're moving, again, a lot of these things, we're moving in the right direction. There is definitely a lot of pressure. The judges feel the pressure, and hopefully these rules wouldn't go into effect probably until March of next year. But I think we're definitely moving in the right direction of getting more disclosure for the amici flotilla.
That's great. Yeah, and I guess to expand upon sort of some of the things that were brought up, Lisa, you mentioned this is coming from the right. Gabe, you of course mentioned Senator Whitehouse. I think there's probably going to be folks out there that say, what makes this different from any other partisan issue? This is just a left versus right problem. What makes these reforms different? And you have non-ideological in the name of your organization. And I anticipate that that's probably intentional. So can you talk a little bit about how this is different from just a standard partisan fight?
Sure. I think, if you look at what we're advocating for, none of these reforms would help one party or another, right? If there were cameras in the Supreme Court, if there were term limits for the justices, if there were enforceable ethics, if there were greater financial disclosures and more information about public appearances, that would not help Republican justices or Democratic justices, Republican lower court judges or Democratic lower court judges. They're all, facially neutral. And, I'm not going to just stop running my organization because there happens to be a 6-3 court majority. Like there wasn't when I started, first of all, 10 years ago. And second of all, there's been a majority of Republican appointed justices since I was like -14. So I'm not just going to, stop doing what I'm doing because of, math. And of course, there's going to be, Occam's razor says there's going to be more issues on the right. There are more justices and judges appointed by the right. Like I'm not going to fight with Occam's razor. So, to me, it's just trying to get the court. Look, sort of the theory behind that is that the judges and justices are acting more like politicians. So let's make them follow the same rules that politicians have to follow, right? Politicians have to put their financial disclosures online. It took a while, but in 2022, we passed a law where judges and justices have to put their financial disclosures online. Similarly, with the High Court Gift Ban Act that we're pushing now, members of the House and Senate can't accept a gift greater than $50. I mean, there's some exemptions, but very few. Greater than $50 from a single source at one time, or more than $100 from that source over the course of a year. And so we believe that the federal judges and justices should follow those same rules. Same thing with public appearances. If you're, appearing before a group, you put out a press release. Don't, be secretly going to FedSoc or ACS or whoever. So I think that to me is, and also with live streaming, Congress has been live streaming its work since 1979. We're not saying, go in the Chief Justice's conference room and live stream that. Brazil does it, which is weird, but like, we're not saying that. We're just saying the public events that the court puts on each year that are critical to our democracy should be viewed by as much of the public as possible. So yeah, I think that's something that as much as people may think I'm on one side or the other, you probably can't really actually guess what my political views are. But regardless of that, I don't think these reforms would help any one party. So that's why we say they're non-ideological.
Yeah, and I would just say, just to add in, Maria, and appreciate what you said, Gabe. And the fact is that the American people get it. The opposition to the corruption that we've seen uncloaked is bipartisan, transpartisan. Independents, Republicans, Democrats agree that this court, their confidence in the court has plummeted. That the court seems to be not acting really like a court, but really, like politicians. And what's really happening here is that the Republicans in the Senate and the House are not actually following the views of the wide breadth of the American people who can see it for their own eyes and know that this is wrong and unacceptable for our highest court, unacceptable for America, quite frankly, to have this sort of corruption allowed to continue unabated, unapologetic, uncorrected, without consequence. And so, why are they, suddenly opposed to any sort of ethics rules, even though some of those members, including Grassley, had supported some reforms in the past? It's because they know that this court right now is so tied into doing their bidding. They don't want to do anything that would basically in any way undermine the power that this court is wielding to advance their partisan agenda. That's my opinion about it. It doesn't make any sense otherwise, because in general, reform, court reform issues in the sense of the ethics codes have been bipartisan, widely bipartisan. It's only if you think that your side, I think, is so corrupt that if these codes applied, your people might be taken off the table, that you would oppose this sort of thing. And that's exactly what the problem is that we shouldn't have judges who are so predictable that they're seen just as the pawn for one particular party in a way that they're willing to countenance this type of corruption. And, the gifts are just grotesque. It's genuinely outrageous that Clarence Thomas would suggest that he has a right to take millions of dollars worth of trips secretly and hide it from the American people, or that his spouse gets paid secretly through a secret arrangement by Leonard Leo, who has helped pack these courts. This is really, it is astonishing. It reeks. And I think, hopefully at some point the cloud will lift and some of these Republicans will come to their senses and support ethics reforms. But they're not doing so is not because they're in the right. They're actually ignoring the will of the American people and ignoring just common sense baseline ethics codes that, quite frankly, when I talk to other judges in the country at the federal and state level, they are appalled at what has been happening at the U.S. Supreme Court. None of them would engage in this type of behavior.
So Gabe, one of the things I wanted to follow up on related to the judicial recusal, first of all, is, I hear there's a rumor on the street that the Supreme Court has different rules than other judges. So when it comes to other judges, what are the recusal standards that they're held to? How does that compare to, however unenforceable, how does that compare to what the Supreme Court is, adopting for itself?
Well, lower court judges are generally pretty circumspect about their recusal practices. They do have, and they have been required to for 17, 18 years now, type out all their potential conflicts of interest, all the names of their relatives, all the names of their stocks, feed it into software. And then if they're pulled on a case, whether it's a trial, if it's a district court, or a 3-judge panel, if it's a circuit court, the software will automatically skip them if there's a conflict in one of the named parties. And on top of that, because sometimes, like, for a while, a lot of judges that had AT&T stock, like, the software couldn't read an ampersand. They have a sheet of paper that's called the conflict sheet, and the clerk is supposed to see, okay, is AT&T or, is some other, person who has a very long last name or whatever, a litigant or the lead lawyer in a case, then okay, maybe the software missed it. But but I'm going to use the sheet and look at it and see if there's a conflict. The justices are supposed to do the same thing. There's a current question as to how many of them actually are using the software and how many of them their conflict sheets are up to date. And the conflict sheets, frankly, change from the time they're a lower court judge to a justice. The only ones that I've seen is Amy Coney Barrett's, and she had Shell as a conflict when she was a lower court judge because her father worked there for a while. But now that she's on SCOTUS, Shell is not a conflict. Now, I don't know. I'm probably of the mind that it probably shouldn't have been a conflict at all because her dad worked there like a million years ago. But if what changed in the time you're in the Seventh Circuit versus SCOTUS, that Shell is no longer a conflict when you have someone like Brett Kavanaugh who is recusing from ovarian cancer J&J talc powder cases because his dad worked for the cosmetics membership association that worked on that issue like also a million years ago. So it's just that's an example that just goes to show you that how differently people on the court sort of look at their recusal responsibilities. In the lower court, they're fungible, right? So if a trial judge recuses, there's always someone else. Just this week, we had a trial judge in Texas recuse because he owned Tesla stock and he was overseeing one of the, I don't know if Elon Musk was being sued or sued. He's always in court. Who cares? But I'll pretend to care about him for the next 15 seconds. There's a Tesla case and he was Judge Reed O'Connor has Tesla stock and he didn't recuse. And it took a while, but eventually we pushed and not we, but advocates pushed and got him off the case, which is the right call. If you own one share of stock, you need to be off the case, which brings up the question of why did judges and justices own any stock? That we can probably talk about at another time. But when it comes to the Supreme, but there's always another judge because there is not another justice who is around that could theoretically take a Supreme Court justice's spot, though there is an argument to be made. John Paul Stevens made this argument to Pat Leahy, and Pat Leahy introduced a bill that when a justice recused, you can call back Stephen Breyer, who's sitting on his hands in Cambridge, or David Souter, who's sitting on his hands in New Hampshire, and bring them to be the ninth justice. And I think there's some theoretical ways to do that via statute. If a justice recuses, there's no one to replace them. And it could be 4-4, and that'd be the worst thing ever, they tell us. We have a duty to sit. No, the worst thing ever would be if there was a 5-4 decision and one of the justices, frankly, doesn't matter which side, because there's Supreme Court precedent that says it actually doesn't matter which side of the 5-4 the conflicted justice is sitting on. Just the fact that they're part of the discussion renders the whole practice bullshit. So, there could be a 5-4 or 4-4, it's way worse, actually, if there's a 5-4 decision and one of the 9 was somehow conflicted and voted in that is way worse. It's not that bad if for like 5 minutes there's a 4-4 case and like the law might be different in 2 circuits. Like they'll find other plaintiffs, they'll find other litigants, they'll go through they'll go through the emergency docket, which is, they'll find other ways to find another case. But the fact that the justices have taken this duty to sit out of whole cloth, thin air, and said it's the most important thing when it comes to a recusal practice is, historically wrong, factually wrong, and ethically pretty disgusting, I think.
And if I could just add, I know I don't want to cut off other questions, but I just wanted to say, I did post a link into the chat on my views on the Shell conflict for Amy Coney Barrett, just in case anyone is interested in an alternative point of view about that. But I think that there are 2 other pieces that are really important. Gabe hit one of them in particular, which is to say this recusal statute has been on the books now for, more than 40 years. And it's mandatory. It says a judge shall recuse if there is, an appearance of conflict, a conflict or an appearance of conflict. And in these instances, I think it's important to recognize that that's actually the law. And yet we have seen that there's been no actual enforcement of it. There's been no enforcement by, or activity by the Chief Justice to do so. In fact, just efforts to defend that court at any cost. But the second thing is that I would say that in my view of that statute is that it's broader than just the stock holdings, because I think at least it should be read more broadly than the stock holdings, because, for example, we know that some of these billionaires have interests. They have financial interests, in the housing industry. And so policies that affect the housing industry affect them. For example, in the case of Harlan Crow, one of the nation's biggest landlords, in essence, or Paul Singer's interests, or some of these other people who have helped put them on the court. But I think even if you look more broadly, what you see is that some of these funders are also funding the groups that are writing these briefs. So they have an agenda. For instance, Harlan Crow's agenda is both his personal, company, his corporate interest, but he also has a very partisan interest that he's been fueling through his electoral donations to candidates, parties, and PACs, and to these groups to basically remake America in a very different image. And so I think that we should have a broader sense of what that conflict is. That's not a universal view. Gabe may have some ways in which he would refine it based on his experience and expertise. But I think from the standpoint of the American public, if you think that a person, that someone spent millions to get you on the court or help get you on the court, and then their groups tied to them are bringing briefs saying you should rule this way, I think a lot of people would say that seems like it would be a conflict. It's complicated, but I don't think it's as complicated as people would think, because there was a case at the same time as the Citizens United decision about the West Virginia Supreme Court justice, and a very specific opinion written by the U.S. Supreme Court about the grounds for recusal if someone helped get someone elected to that court. And so I think there is some precedent to help, and I would love to talk about Citizens United if there's time, but I'll hand it back to you, Maria.
Thank you. Okay, I'm going to roll through one tiny clarifying question that Gabe, I'm going to shoot to you, and then I will give you both sort of a wrap-up answer for this final moment. But you had said in the course of us talking earlier that for HR 8830, that was the one that has so far 0 Ohio electeds that have endorsed it so far. Is that right?
Yeah, that's the High Court Gift Ban Act, and it would ban all federal judges and justices. So not just the 9 Supreme Court justices, but also the 2,300 lower court judges who have plenty of weird gift acceptances, and it's roughly 50-50 Dem appointees and R appointees. It would reduce, or it would ban their ability to receive gifts greater than $50 from a single source at a time, or greater than $100 from that source over the course of the year, which is the rules of the House and the Senate. It would also give a little more accountability on judicial junkets and reduce the amount of personal hospitality that judges and justices can accept. And the penalties would be the same as if you're filing, if you're lying on your financial disclosure, which is referral to the Justice Department. And, the Justice Department hasn't been as muscular as I would have liked them to be in the whole Justice Thomas thing, but it doesn't mean that they don't have the ability to investigate what's going on at 1 First Street. So yeah, there's not a single, currently it is a Dem only bill. There are Republicans that are interested, but they haven't signed on. And to me, it's, so in terms of again, action items.
I was going to say, I'm
getting your reps to co-sponsor. We spoke to Sherrod Brown. He said he's busy with an election, which I get, but there's no reason that that should stop him. Haven't spoken to JD Vance because haven't spoken to him. And so, right. I think the Dem House members and even the Republican House members, there are folks on Jim Jordan's staff that work with Democrats on court issues. For those of you who have to deal with PACER, Congressman Jordan is an advocate of free PACER, and that bill has not been introduced yet. It will be soon. But there are opportunities, specifically with the Gift Ban Act, to try to get your reps involved.
Great. Okay, so we've got that action item for our listeners at home, and then we also have that newly announced amicus brief reform that maybe it's worth contacting your elected over as well.
Or you can contact me. The links are bad. The links are bad on U.S. courts. So just Gabe at fixthecourt.com if you're interested on that. I'll send you the link.
There you go. Great. I am going to bundle all the last questions together, and I'm going to give you a whole 30 seconds each to answer that because we are running out of time. So good luck. But we have some questions about, expanding the court, term limits, the Biden-Harris reforms. We've got all sorts of different ideas floating around. And ultimately, I think the overarching question is, what's the quickest way for this court to get back on track? If you had to just very, very briefly, 30 seconds, no more, tell us how they most effectively can make it count. Gabe, I'll start with you.
Huh?
Yeah, I mean, look, the court's not going to fix itself. I mean, I think that's become very clear in my 10 years of doing it. And, Congress has exerted oversight over the judiciary in very muscular ways, roughly once a generation. The Judiciary Act of 1789, add 20 years up until roughly 1988. And things changed at the court in terms of the types of cases they hear, their jurisdiction, their writing circuit, how many justices, et cetera. So to me, it's just getting Congress to work that muscle. I don't personally support expansion because I don't want there to be 87 justices in an arms race. People might disagree. That's fine. I like term limits. But to me, the number one issue is just getting Congress to engage in a muscular way like they did in 1800, 1869, 1893, 1911, 19, et cetera. So whatever first step that is, whether it's the Gift Ban Act, whether it's putting Justice Kagan's words about enforceable ethics to law, like Joe Biden also said, it's really just, it has to start and end with Congress, because the judiciary, left up to its own devices, is going to continue down this really depressing path.
Okay. All right, Lisa, close us out.
Sure. I'll just say that, there are a number of really important and good reforms. We've mentioned a number of them, and we'll definitely send materials around about them, including term limits, including changing jurisdictional rules for the court. There's a really interesting conversation happening about court expansion, or how to do it, ways in which to move forward on that. And I think these other ethics code provision fixes are really important as well. I would just say that I was really happy to see the White House, President Biden and Vice President Harris support court reform. This is a major advance forward. It's absolutely necessary. It's not a partisan issue. It shouldn't be a partisan issue. This should be about protecting the integrity of our courts and the integrity of the decisions by our court. I think that this is an issue in which we should be talking with our friends and family about. I think, in my personal view, the Supreme Court is on the ballot in many ways, because this court is going to continue to do harm until we have enough people in Congress to move forward reforms to protect our rights and to protect the integrity of the court. That's not saying endorsing a particular person or another, but it's just to say, this court is not just like out in the ether. It's issuing decisions that affect our lives, and it's thumbing its nose at the types of rules that other judges at the federal level and states, follow as a matter of course. And it is a matter of just enormous importance, because so much is at stake. And I have to say that I agree with the American people. This court is out of control. It must be brought to curb. It must be reformed in order to restore confidence in our courts, and and really to restore the rule of law and protect the rights and freedoms we all hold dear.
Great. Thank you so much. Well, thank you both. I know I learned a lot, and I hope the rest of you all did as well. I'm sure that you can follow up with these fantastic panelists later, and I will pass it back to Catherine.
I'm talking away on mute. This is what happens when I listen really intently, and I always enjoy these kind of conversations. And you provided a lot of things for us to think about, a lot of things for us to digest. I did want to let people know that what we do plan to do is send an email that'll have the recording, it'll have the slides. Well, it'll also include all of the links that were sent today, so that you'll have some things that you can look at. However, I never want us to leave without taking action, because there is that thing of we have a vision of an impartial and fair courts, and we need to take action today. You can leave it till first thing in the morning, but you need to take action. And I think a simple way to do that is to support the High Court gift ban. And so we'll be sending you the links so that you can take action. And I think it's incredibly important for us to let Congress know what we want, to let the courts know that we deserve better, and let's do what we can to stop these kind of lavish gifts that certainly sway people. Now, once again, I wanted to say thank you to Maria Bruno for walking us through this. We have some lovely resources that we're going to be sending you, including some videos and some podcasts and some articles and fact sheets and all sorts of things. And then I wanted to say a big thank you to Gabe, a big thank you to Lisa. And then I wanted to send us all off home. And to say once again, thank you so much. I'm just really glad that we're talking deeply about these things. And the next webinar we're going to do is going to be focused on the Ohio Supreme Court. And so we need to always be thinking about what's happening when it comes to SCOTUS, but incredibly important decisions are made by the Ohio Supreme Court and state courts, state high courts all over the country. And so we look forward to doing another one of these webinars very soon. And with that, I'm going to bid you all adieu. Thank you, everybody. Have a good evening.